You are watching the LemonAid Podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hello and welcome to LemonAid Podcast with lemon law expert Shalev Amar. I'm your host, John Clements, and today we're peeling back the layers of an important topic for anyone navigating the lemon law world. So first of all, Shalev, it's great to have you back on the show.
Great to be back.
Yeah, absolutely. And so today we're going to answer the question, how many repairs are too many? Understanding the lemon law threshold. So Shalev, to get us started, what is the threshold for determining how many repairs are too many before a vehicle qualifies as a lemon under the law?
Well, typically state lemon laws have what are called presumptions, but presumptions are not exact requirements. So the typical presumption is if there's 3 or more repairs for the same substantial defect and the problem continues to exist, it's presumed that the vehicle's repair history is unreasonable and it would likely qualify as a lemon. If it is something that could cause death or serious bodily injury, in some states it only needs to be 1 or 2 repairs. Other states have presumptions of 4 or more repairs. So most commonly the presumption that you will see is 3 or 4 substantial repairs, and the issue continues to exist. So internally at our firm, the threshold that we have is 3 or more repairs for at least a somewhat substantial issue. It doesn't have to be the most substantial. So anything from vibration to transmission, engine, non-starting, hesitating, etc. And so every state lemon law, basically, the threshold is that the repair history is unreasonable. The law basically says at a certain point, enough is enough. The challenge is presumptions are not really requirements per se, because what a presumption does is it shifts the burden of proof from the consumer, the one bringing the claim. Typically, the one bringing the claim has the burden of proof. It shifts the burden of proof from the consumer to prove that the vehicle's repair history is actually unreasonable, and therefore the vehicle's a lemon, to the manufacturer to say well, for whatever reason, even though this appears to be unreasonable, you shouldn't look at it as being unreasonable. So it shifts the burden of proof to the other side. It puts the shoe on the other foot, actually.
Oh, I see.
But a presumption is not an actual requirement. In our view, if the repair history is unreasonable, then you don't need the presumption. So we believe at least 3 repairs. That's plenty of repairs to try and resolve a problem. If you've had the transmission repaired 3 times and it's still acting up, that is unreasonable, even if the presumption in your state is 4 or more repairs. So our view is 3 times. That's the threshold in virtually any state in the country.
I see.
Especially if it's at lower mileage. Because, most lemon laws have mileage limitations as well. On the high end, 24,000, but typically 12 to 24,000. There's a couple of states that have no such limitation. But let's say you're in a state where the lemon law period's 24,000 miles, and you've had 3 engine repairs in 5,000 miles. And let's say the presumption is 4 or more repairs. Well, you have 24,000 miles to reach that presumption. In our view, even without the presumption, the fact that you've had 3 engine repairs in just 5,000 miles, that's unreasonable. It doesn't matter if you never meet the presumption. That shouldn't be happening, that you get a brand new vehicle, you use it basically 2 or 3 months, about 5,000 miles, and you've been in the repair shop 3 separate times for the exact same problem. That's unreasonable. In our view, that would qualify as a lemon vehicle.
Yeah, that sounds extremely I would be very upset if that was my car. So I'm in agreement with you there. And I want to dig into this a little bit too about this idea of repairs, because you mentioned substantial repairs. So the engine has a problem, the transmission fails. Is it any major repair or defect that would count towards this number, or are there some that count, some that don't count? Where is that line drawn?
Well, unfortunately, like a lot of areas in the law, the line is squiggly and it's gray. And so, because there are defects that could be argued either way. So what are gray area defects? I would say entertainment system, I would say vibration, because it's also a matter of degree, what's happening. Is the entertainment system just not working, or is it making this loud screeching sound no matter what? I mean, So obviously that's a factor. The vibration, is it like a slight vibration at certain speeds, or is it like constant shaking? So obviously degree matters as well. But that's where it gets a little squirrely, and it can kind of be argued either way. And the degree really matters. I think certain defects, they're just clearly substantial, and there's really no way you can argue against it. And it's typically when it's a major component, and it's something that's crucial to making your vehicle operate properly and be able to drive. So your transmission, your engine, your battery, the starter, things like that, steering, because obviously that's safety related. So things of that, the vehicle being able to properly accelerate, the vehicle being able to stop, those are clearly substantial.
Yeah, and so speaking of like safety, so there's safety items and there's convenience items. Does that play a part as well?
I would say so. I would say the more a defect implicates a vehicle's safety, the more likely it's to be just obviously substantial. Like there's no debate about it. The more it turns into convenience, then I would say it's kind of a hassle factor. Even then, I would say the degree of the inconvenience matters. And also, it's kind of like a sliding scale. So let's say you have a major safety problem or defect or condition. So I would say that doesn't need to happen as many times to qualify, because in some states it's even written like that in the law. Like the presumption is much lower if it's something that could cause serious bodily harm or death. So I would say if it's something like your vehicle cutting out in traffic, basically stalling out while driving, that's something that could happen twice that could qualify as a lemon, because it's so dangerous and it's such a major problem. On the other hand, let's say it's vibration and your vehicle vibrates when you drive over 40 miles an hour. So that's more of an aggravation factor. The vehicle might still drive perfectly straight and you have no problem steering or anything like that. So it's more just an aggravating vibration. But I would say, look, if you've had that repaired 6-7 times, even if it's not as substantial as your vehicle cutting out while you're driving, the fact that you've had it repaired 7 times, that in itself, in our view, it's kind of like a sliding scale. It's kind of like a stair step. The fact that you keep having to be inconvenienced and that the problem is not being repaired, is remaining, that starts to become more substantial.
Yeah, and actually, I want to dive into that too, because and we've talked about this on previous episodes, but part of the inconvenience of just having to spend your time without having a car or waiting on the shop to get it back to you, like that's a big deal. Your time is valuable. So how does that time factor increase the likelihood of this being a valid lemon case?
100% it does, because there's 2 main factors under state and federal lemon law. That is the repetitiveness of repairs. Like how many times are you going into the repair shop, having to drive back and forth, having to turn your schedule upside down, having to cancel plans. I've had clients who've been fired for their jobs because of their lemon vehicles. Like it can get that bad because they're constantly in and out of repair shops and they're missing work. But another factor, an independent factor, and sometimes it can be interrelated, is time in the repair shop. So especially if you have a luxury vehicle or an expensive truck that you've saved up a lot of money to buy and is costing you a lot to pay for and to insure. And so let's say you have a heavy duty truck, or let's say you have a luxury vehicle and they're putting you in a tiny tin can of a rental vehicle. It's not even close to what you're paying for. Well, that's not fair. And you're paying for A and you're receiving basically C or D. So like an A-level vehicle and you're receiving a C or D level vehicle. Well, that's not fair. Sometimes they won't even provide you a loaner. So you're completely without a vehicle. So let's say you're without your car for 2 months, you're having to take Ubers every day, or you're having to pay for a rental. Well, now you're out of pocket, hundreds, maybe even a couple $1,000s.
Yeah.
Or while you have a car that you're paying for as well, that's just out of commission in a repair shop. So time in the repair shop is a major factor as well.
Yeah. And I didn't even think about the idea that if you have to hire an Uber or rent a car out of your own pocket, like, yeah, now there's even more money that you're out that you never should have been out. Didn't even think about. See, that's why you're the expert. That's why people need to call you. So speaking of the repair shop, is it important to keep records of each repair attempt, and does that kind of help with just determining whether a car is a lemon and getting a resolution to that?
Yeah, that's critically important. The number one piece of evidence in these kinds of cases is the vehicle repair orders or work orders. It's basically the repair invoices. So I always urge anybody who's dealing with a lemon vehicle, make sure you get a work order or a repair order every single time when you pick up your vehicle from a warranty repair. You don't ever want to get caught in a he said, she said, or he said situation. The repair records are business records, and they're basically an admission by the other side of the defects in your vehicle. And so there's no reason to get into tit for tat and he said, she said. Just get the records. And if they're not giving you records, be nice. You get more with honey than vinegar, but be nice, but at the same time be adamant that, hey, you need to give me an invoice for what was done, even if they don't find the problem. If they don't find the problem, okay, say, I got you. Please provide me a repair record showing what diagnosis was made and that you didn't confirm the problem, because I am experiencing this problem. I have better things to do in my life than hang out at repairing dealerships. And I don't want to be blamed, frankly, if this problem happens again and my vehicle totally breaks down and maybe the engine has to be replaced or the transmission has to be replaced. I want a record showing that I've brought my vehicle in to be repaired. So this can't get ultimately blamed on me. And so, again, be nice, but at the same time, persistent and adamant about being given repair documentation, whether repairs are done or not. Always get invoices.
And you're very, very specific about your wording there. I just want to make sure people caught that. There's two terms I think you said you should be looking for: repair order or work order. Is that correct?
Correct. That's just the verbiage for it's basically a repair receipt. Every time you go in, they should be documenting the mileage in, the mileage out, the date in, the date out. What are the defects or conditions that you've complained of? What diagnosis was made? Was the problem confirmed? Was it not confirmed? Was the problem covered under warranty? Was it not? And what was done to repair the problem as far as repair action undertaken and any components that were replaced? And so very, very important that you get that every time. Because the thing is as well, even if they don't diagnose the problem correctly one time or they don't confirm it, if you then bring the vehicle back a week or two later and they do a repair, then we argue that the past time was a misdiagnosis and should still count as a repair attempt towards your legal claim. And that time in the repair shop should also count towards your legal claim. But you need the repair records to back that up.
Yeah, and I'm glad that you kind of specified the different kinds of information that you should be looking for. It's a nice little mental checklist, right? To make sure that, yes, indeed, I got the right information. It's all there. I know that I'm getting the right thing.
Correct.
And then what would you counsel someone to do if they're in a position where they've had multiple repair attempts on their car, but they're just not quite sure if it qualifies as a lemon or not? How would you kind of handle that situation?
Well, the easiest way to handle it is to contact an attorney and just most law firms do provide free evaluations. There's some that don't. Some will charge you, so that should factor into your decision as far as who you have review the matter for you. But most lemon law attorneys are happy to take a look at your vehicle's repair records and let you know what they think. But yeah, as far as yourself, just 3 is the magic number. If you've had any particular problem repaired 3 or more times, that should ring an alarm bell for you. And at the same time, 30 days, that's another magic number. So either 3 or 30. Those are the 2 things to look at. If you've had 30 days in the repair shop, either for one repair or for all the repairs combined, that should also ring an alarm bell.
All right, cool. So 3 repairs for 30 days. Again, I appreciate that those little bite-sized things people can take away from and just have that in their mind. So yeah, that's amazing.
Well, it's not for 30 days. It's either or. So 3 or 30.
Oh, okay. Got it.
You don't need both,
Thanks
just one or the other.
Perfect.
It helps to have both, but
Yeah.
but one or the other should be sufficient.
All right. Well, Shalev, it's been really interesting and instructive to have this conversation today. And I just want to thank everyone for joining us on the LemonAid Podcast with lemon law expert Shalev Amar. So please take the time to like and subscribe to the channel, leave us a review. And Shalev, you've got a number of websites and I think a phone number people can call. So how can people get in touch with you?
So most of our websites were regional. Other than Nebraska, we are mainly regional to the Southwest and the West. And our websites are the state, followed by lemonlawadvocates.com. So that applies to several states. So for example, Oregon, it's OregonLemonLawAdvocates.com, Arizona, ArizonaLemonLawAdvocates.com, and it's LemonLawAdvocates.com in the state. Also for Colorado, Utah, Nebraska, which I mentioned earlier. We're in the process of adding New Mexico and Minnesota. So by the time you see this, we may be up and running in those states. We're also currently in Washington state. So that's Washington, lemonlawadvocates.com. Then a couple of other URLs. In Nevada, it's nevada.lemonlaw.info. And in California, it's California Lemon Law Advocate, just singular.com. And we also operate in Utah, so that's utahlemonlawadvocates.com. And our 866 number is 1-866-904-2627. So you can check out our websites for more information, or feel free to call us for a free evaluation.
All right. Definitely take them up on that. And for those of you listening, hope you have a great day. And Shalev, again, thank you so much.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.